It is June 15th of 2026, and this is the Court Gallery. Court Gallery. In today's compilation, the excuses are wild and the consequences are very, very real. We start with the sentencing for a man who thought damaging tires he bought was a valid defense. Spoiler alert, it wasn't. Then, things get truly unbelievable when a 38-year-old man tells the judge his landlord, who also happens to be his niece, said he could just stop paying rent to save up money. The judge is not impressed. And we close with an intense protection order hearing where a man claims his ex threatened to shoot his children, but she fires back accusing him of being the real harasser. All this and more starts right now.
Okay, let's go on the record in the matter of the City of Lincoln Park versus Hassan Faisal Abid Al-Ajib. 25th District Court case number 26L09040M.
Morning, Edward Zelenak on behalf of City of Lincoln Park, Your Honor.
Thank you.
Good morning, Your Honor. Edward Hoover, defendant, P62763, who stands at the podium.
Thank you. And sir, your name for the record, please.
Hassan Al-Ajib, Your Honor.
All right, thank you. And is Miss Sabo present?
No, she's not, Your Honor. They have no further statements to add.
Okay. Okay. The court will note that this matter was originally charged with disorderly tampering with or malicious destruction of property. Mr. Hassan Al-Ajib entered a plea of no contest in this matter, and 771 if eligible. Yes. Before counsel, has there been any, did you have an opportunity to review the pre-sentence report and recommendation with your client?
We did, Your Honor. No objection, or corrections, excuse me. That's all the recommendation.
All right. The court will note that there does seem to be a correction that needs to be made. It shows December 14th of 2015 as the instant offense, but that's 2025.
Although that's possible, Your Honor, in the scope of things in the Lincoln Park Court, they put the file papers in backwards and everything else, so you never know.
You never know, except this one, I think the factual basis was December of 25.
You're right.
Okay. All right, Mr. Al-Ajib, anything that you'd like to say?
No, ma'am.
How is the parenting exchange going with the third party?
Still proceeding.
Okay, Mr. Holmberg?
Yeah, no problems. So,
And the people have received no report of any problem.
so there's been no issues.
Okay, Mr. Al-Ajib, apparently it appears as though you felt as though you had the right to damage the tires because you purchased them. That's not the case, which is why you're charged, sir. So if you purchase the tires or not, if they don't belong to you, they don't belong, it's not your vehicle or whatever, you don't. That's not a valid defense.
I understand.
It appears though you and Miss Sabo are no longer in a relationship. Would that be accurate?
Yes, sir.
All right, here's what the court's going to order. The court, and this may seem a little bit disjointed because this is different from the way that my probation department puts together their recommendations. The court does find that there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice. to be reasonable, proportionate to the seriousness of the matter, taken into account the circumstances surrounding Mr. Al-Ajib and the legislative guidelines. The court's going to order 18 months probation. You're not to violate any criminal law of any government. You're also not to leave the state of Michigan without permission of the court. You are eligible for early discharge. Which I'll go over shortly. You're eligible under 771.1 with this caveat, sir, because you've had a number of opportunities on other matters. One violation and your under advisement status will be revoked. You are to report truthfully to your probation officer as often as your probation officer may require, whether in person, in writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You are not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition, sir, so the court can monitor your progress in maintaining abstinence and sobriety. You are to pay restitution, but I don't believe, has there been a restitution amount determined, counsel?
It was already paid.
It was already paid? Okay.
It will be added, will replace. Is that correct, sir?
Yes, sir. Yes, sir.
All right. The court's going to order no contact with the victim in this matter by any means whatsoever, and you shall not be within 100 yards of Miss Sabo.
I think when we were here last time, William might correct me, it was Lee can enlighten me more. I believe he waived that there was no problem with him having contact. Is that correct?
It was just for the custody and visitation.
Correct. So that can be via third party, because I believe a third party's been doing that, correct?
Yes, sir.
Correct. So the third party will continue.
Okay.
You're not to have any weapons or firearms. I don't know. Do you have any of those, sir?
No.
You shall not carry, purchase, or possess a firearm or ammunition. You are to complete a 26-week anger management program. The rehabilitative goal for that condition is so that you can further have assistance in learning how to properly respond to situations that are emotionally upsetting to you, so this doesn't happen again. You are to you're not to use any mood or mind altering substances and not engage in use of alcohol, which I've already specified that. You're currently full-time employed, correct, sir?
Yes.
All right, you just have to submit that to probation, verification of that. And the recommendation here is that there's any probation violations, defendant shall serve 30 days jail. However, that seems to go against the statute and with the technical violations and whatnot, counsel. So I'm not going to order that at this point.
Thank you.
Sir, let me be very clear with you. If there's a violation, there is jail on the table. Whether it's 30 days or less than 30 days, it's for this court to determine. But I'm not going to indicate 30 days jail if there's any probation violations, because that's not consistent with the statute.
Thank you, Your Honor.
Any questions? Counsel?
Very good. Thank you very much.
Okay. And it's showing that there's various, I don't know what the screening or assessment fee is for probation. Either one of 75. Okay. Okay, let me see here. All right, the court's going to order a $300 fine, $75 for the screening assessment fee, $810 supervision oversight fee. That's $45 a month at 18 months. Since you are eligible for early discharge, sir, up to half of that could be waived. $300 to cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. So I'm pretty sure that my math shows $1,610. Okay. Lincoln Park, the 25th District Court may correct that once they recalculate it. And then you can set up your payment plan with probation. Okay, anything else?
Thank you very much.
Thank
All
you,
right,
Your Honor.
as I did indicate, sir, you are eligible for early discharge as long as all of the following have occurred. You complete at least half of the original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort to making full payment. Any questions, sir?
Okay.
Okay.
You'll see me.
All right, sir, you're going to stop back over at the 25th District Court. I'm not sure if that's going to be today or tomorrow. Do you know, Mr. Zolnak or Mr. Holmberg?
I would probably go tomorrow. It'd be life easier because they will say.
Correct. Okay.
Might be better today because of the felony date. Don't you
Yeah,
think?
well, it's kind of quiet in the morning. There's Angela in the afternoon. She worked doesn't start his exam started at 11, and then I think Judge Custom started.
Okay. All right. In fact, you can probably take it, take this with you, I think.
Judge, you want me to take it or want Mr. Holden?
Well,
I'll take it. The city thanks you for your indulgence here, Your Honor. I know you've received a whole draft of them. You're the number one draft.
yes, it seems to be. Okay. So I just need to have my staff make a copy of a couple of things so that we can that for our record, for my records, and then you can take this back with you.
Thank you, Your Honor.
Okay, so I just need a copy of this. Let's go off the record for a moment. We are on the record in the matter of Casey Holowinski, 2514544A.
Good morning, Your Honor. Mr. Shunky here on behalf of my client, Bill Approaches.
Good morning. Your name for the record, please.
Casey Holowinski.
Okay, well, so today is the date scheduled for a bond violation. Miss Holowinski was arraigned on her warrant April 23rd of 2026. And the court indicated that we would reinstate the bond and bond conditions, and one of which was to test randomly, and then to be re-referred to the treatment court here as your client requested she wanted. And it's my understanding that your client has not tested as ordered. And so therefore, we are here for a probation violation. I mean, a bond violation.
We're not going to be having a hearing. My client will admit to the violations.
Ma'am, please raise your right hand. Do you solemnly swear from testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
Can you just speak up, please?
Yes,
Are you picking her up?
I am.
Okay. Okay, and so ma'am, you were ordered to test randomly by this court, correct?
Yes,
And as to that allegation that you did not, how do you plead?
guilty.
You understand your rights regarding bond violation matters in this court, correct?
Yes,
And you've gone over those rights with your attorney, correct?
yes,
And you also understand the possible penalty as a result of this, of your plea.
yes,
This court could revoke your bond, could issue additional conditions, have you complete additional terms, or a combination of all that. Do you understand?
yes,
Knowing all that, do you want to continue with your plea?
yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No,
Okay. And if you were to test right now, is there anything in your system?
We,
When's the last time you used it?
yeah, yesterday.
Are you under the influence of anything, ma'am?
No,
Do you have a valid prescription for marijuana?
yeah,
You do.
yeah.
And where did you get that prescription from?
It was a doctor,
Okay, a marijuana clinic doctor or your
Yeah.
treating physician?
a marijuana
Okay, well, that's not going to be sufficient, depending on when you obtain that prescription, which is when? When did you obtain that prescription?
last year.
Last year.
Yeah.
Did you submit that prescription to anybody?
My probation officer.
You did.
Yeah,
Yes?
yes.
Okay. All right, counsel, if you can please voir dire your client.
Did you feel the test is ordered on May 6th, May 11th, May 19th, and May 26th?
Yeah.
And those were for drug and ETG testing, correct?
Yeah.
Says by the
The court is also satisfied and that the plea is knowing, voluntary, and factually accurate. The court will accept your plea to bond violation. And as to sentencing counsel,
Your Honor, I respect requesting leniency that be considered regarding this case. She is currently living in Lincoln Park. She's at Hope House. She's been applying at several jobs. Her transportation has been very difficult, but she hopes to take her sobriety. She would like to be reunited with her two boys, ages 8 and 4, and she's still optimistic to complete any programs and terms and conditions ordered by this court. Thank you, Judge.
okay, and ma'am, how long have you been at Hope House?
A week. Like a week and a half.
Okay. And before that, where were you?
Sandy's house.
Stanford House?
Yeah.
Right. And so, why are you no longer at Stanford House?
I was unable to pay the rent.
Is that the reason why, ma'am?
Yeah.
Have you ever, heard somebody asking you specific questions because they already have the answer? So, all cards on the table. And now's the time to be honest. Why are you no longer at Stanford House?
Yeah, I mean, I couldn't get a job. Wasn't able to pay the rent. So she told me I couldn't stay there.
Are you sure that's the only reason why, ma'am?
Yeah.
Okay. Because that doesn't appear to be the only reason why. You were actively using, which is 100% against the house rules at Stanford House, correct?
Yeah.
Right. Okay. You know, it's probably against the rules at Hope House. I don't know what the rules are regarding prescribed marijuana, but
Yeah.
do you still have a peer recovery coach, ma'am?
I'm not at the Hope House. I have to get one. Well, I mean, I'm going to counseling still.
Okay. And how's that going?
Good.
When's the last time you used any substances other than your prescribed marijuana?
It's a month.
And why haven't you participated in, why didn't you go to any of the testing, ma'am?
Just I couldn't get a ride there, and I'm just I can't struggling paying for it. It was $35, and no one's really able to help me pay for anything.
Did you attend your PSI, ma'am, May 4th of this year? With probation?
Yeah,
All right. And you didn't return any outreach attempts from the treatment court?
no, I have to pay my phone bill also, so I can't make phone calls. Yeah.
Okay, ma'am. Where have you applied for work?
On Indeed, I applied to some flower shops, serving, Meyer, some gas stations.
All right. The court's going to order 10 days jail. I'm going to suspend that jail. Ma'am, do you have to test while you're at Hope House? Do you randomly test?
Yeah,
You do. Is that yes?
yeah.
Okay. Ma'am, I'm going to have you come forward, please. And good morning. If you can please state and spell your first and last names for the record, please.
Angela Strelak,
Can you spell your names, please?
Angela, Angela, Strelak is Stratelak.
Okay, thank you. And just keep your hands out of your pockets, please.
Oh, yeah,
Okay, and ma'am, and you run Hope House, correct?
I do.
Okay. And is there random testing available for Miss Halowinski?
Yes, there is. There is, twice a week, we randomly test. She came in, we did an original test, which she admitted that she had used. That was a week ago. Just shy of a week.
She admitted she had used something more than marijuana.
Cocaine.
Okay.
President's Creek. And then we had our meeting on Wednesday. We have a group therapist who comes in, Rolando, and he does group at the house. He stayed for the majority of the group, but then just went in the kitchen and walked up. So we talked about that's disrespectful. He was out until midnight last night, and she texted me to get in the house, and I said, no, you don't come in at midnight. I'm not going to be doing and up at a meeting at 7:00 anymore. So with some so I have a work schedule. So she knew the rules, and I did not know that she can't use marijuana and be there. And you can't come in at midnight when you've only been here for 6 days.
Okay.
So
Well, I was told it was midnight on weekends.
Sunday is not a weekend night. It's leading into the weeknight.
I thought Sunday was considered a weekend.
What were you doing out until midnight, ma'am?
And I got some food, and my friend dropped me off late after. We went to a restaurant.
You don't have any money for a job. You don't have a job. How are you getting food?
He paid for it.
So why don't you have him pay for your drug testing?
I didn't ask him.
Right. So here's what this court's going to do. Ma'am, you indicated that you haven't used anything other than weed for a month. And that's not accurate because you tested positive for cocaine a week ago when you went into Hope House. So I think at this point, what needs to happen for your own benefit, ma'am, is that this court's going to revoke your bond. You're going to be, if you would like treatment, ma'am, the court's going to tether you to treatment.
I would just really like to stay in Hope House and.
Well, then you need to learn how to follow directions, ma'am. You need to learn how to follow house rules and stay in recovery, which you need some additional assistance with. So that's what we're going to do. We're going to be tethered to treatment through the Wayne County Jail. So what will happen is you'll be transported down to the Wayne County Jail today, and then they will screen you. And within the next couple of days, you should be housed in an inpatient treatment facility, which seems to be exactly what you need.
Can I just continue with Hope House? I really want to.
Ma'am, you're not hearing me.
I just really want to get a job, and
That's great. Perhaps after you have been in inpatient treatment, because you need to be in recovery, ma'am, before you can be able to hold down a job. And that seems to be a struggle for you right now. So you're going to go in patient treatment. Perhaps there will be a place at Hope House afterwards, after you've been in your treatment and you can maintain your recovery. Okay? So you're going to go out these doors today.
Am I going to rehab or?
Yes, you're going to go to the Wayne County Jail. They're going to find a rehab facility for you, inpatient, and then you will be transported there. Okay, well, no. Right now, you're just going to go this way, and then Miss Angela will retain your items, and then she will. You can contact her when you are released for those items. All right, let's go off the record. All right, and then we are on the record in the matter of Linda Latola versus Daniel Martinez doing business as Discount Dan Auto Repairs. And so, Ms. Latola, your name for the record, please.
Linda Latola.
Okay, who's Kelly? Let's go off the record. Who's Kelly? Do we know when she's here now? Is she gone? I think so. I don't know. Okay. All right, we're back on the record. And so, Ms. Latola, your name for the record, please.
Linda Latola.
Okay, please turn your camera on.
I'm trying to. It says integrated camera. I don't know.
Okay, do you have something? It's a black screen, so it appears as though there's something sitting over your camera.
Oh, okay. There I
There
go.
we go.
Sorry.
There we go.
It's
Just
a
call
new
me the IT
computer.
guru today. Okay.
Thank you.
And so, and then counsel, your appearance, please.
Mark Kohler on behalf of Discount Dan Automotive, P69571, Your Honor.
All right. And so, Mr. Martinez, your name for the record, please.
Daniel Martinez.
Okay. So today's the date scheduled that I had you all return back today. Because I needed to do a little bit of research internally to see what occurred, because there appears to have been some procedural defects in this matter. So by way of the record, this matter was originally in small claims court. It was removed from small claims court in March of 25. No formal appearance was filed. We don't have a formal appearance being filed until December 1st of 2025. There was not an answer filed in this matter that when it was moved to general civil. Those are all concerns that this court needed to look at, and there was not any record of having an answer filed. And the reason this court took the time to look into that was because this was sort of a hybrid file, because small claims, it was paper, and then it was it's my file because it's in general civil, and we are in my file court. So the
Interesting.
The court does not have any record of an answer being filed prior to this default being entered. And in fact, there was an email communication sent by Ms. Schmidtke as to whether she was following up with Mr. Kohler because we had not received a written answer. There is in the file a document, a proof of service dated February 17th regarding an answer and affirmative defenses. However, that's attached to the emergency motion to stay. There is not one attached anywhere into this court's file prior to this motion being filed. So as such, the court does not find that there's a basis to set aside the default judgment. And procedurally, counsel probably would have made a bit more sense. Well, it may have been a bit less convoluted if the motions were separated. Because I believe that you're also objecting to the garnishment. So that's a separate issue that we can address, because this court's not going to set aside the default judgment. The court's going to deny that motion. The court had previously granted a portion of your emergency motion to stay the garnishment until this court hearing had been heard. And so, counsel, we can proceed with your objection to garnishment.
Your Honor, if I may first address your ruling relative to the judgment being set aside. I have not found the email, but however, when I turned in the paperwork to remove from small claims, I included an appearance. And so I'm kind of surprised that you said no appearance is entered. And also the fact that I was contacted by email, which you read, which I don't have. And so I'm slightly confused how I was contacted if the court didn't have an official appearance.
Because your information was on the removal to General Civil Counsel.
All right.
That's why. And so my civil clerk sent out a courtesy email, which she didn't even have to do.
I understand, Your Honor.
She sent out a courtesy email, and that was, I believe, July 22nd is when I stated that was done. It was July sometime. I said that on the record last night. It's July 22nd at 9:51 a.m. of 2025.
I did not see that email whatsoever in my inbox, Your Honor. I'm sorry. Second issue I have is never received a notice of the default. Did you find that?
Your client did.
My client did?
Yes, because there hadn't been an appearance issued, counsel, so it would not have been sent to you. It would have been sent to your client.
My client has not indicated he received a default. I don't know if he did. I know the original small claims case mentioned a different auto shop, which was incorrect. And that was corrected actually on my information as well. So I'm not sure where it was sent.
My clerk indicates that she mailed out the default to the plaintiff and the defendant. And, counsel, what is the address of your client's business?
Dan, you unmute and give the address, please.
It's 1333.
1338. How long have you been at that?
Probably 4 years.
Lucia, can you please look up to see what it shows in our system as the address for Mr. Martinez, please?
I'm saying 1720 Eureka Road.
How long has it been since have you ever been on 1720 Eureka Road?
That's the other Dan.
The other Dan?
That's Dan's auto repair.
I'm sorry?
Dan's auto repair. He's 2 blocks from me. He's 1720.
And Discount Dan's is 1333 Eureka.
Correct.
Ms. Latola, how did you get the address for 1720 Eureka?
I didn't get the address 1720. It's always been 1333 Eureka, Building 2. That's how I have it on my documentation.
Well, interestingly enough, Mr. Miller, the court officer, served by posting to 1720. And we have it listed in our system as 1720. So the court's going to have to rescind its order denying the motion because, ma'am, Ms. Latola, you have on here on your affidavit and claim on your small claims, 1720 Eureka Road. You completed this, didn't you not, ma'am?
Whatever I filed, but it was 1333. It's been that on there.
Ma'am, I am looking at your document right here. 1720 Eureka Road is what you filed on your affidavit and small claims that you signed in, it appears, January of 2025. You provided us that address. That is not where this defendant's business is. So therefore, Mr. Dan did not have notice of the default. So the court's going to have to set aside the default judgment. So we're going to grant the motion and set aside the default judgment. All collections are stayed.
Excuse me, Judge, I have that request and order to seizure and it has all his information on there.
Ma'am, I understand that that has his correct address, but the address that this court has is 1720 Eureka Road. So any
Yeah, but
communication,
who entered that?
excuse me, do not interrupt me, please. Any communications would have been sent to 1720 Eureka Road. This individual would not have received notice of the default judgment, nor did he receive notice of this action.
But it's
because
okay
the
for him to
process
do
server-
what he did to
I
my
just said
vehicle.
stop interrupting me, Miss Latola. I said stop interrupting me. The process server served it by attachment to 1720 Eureka Road. That is what I'm reading right here. He attempted service at 1720 Eureka Road.
Well, then how did it get processed if he didn't?
You have 1720 Eureka Road. We have 1720 Eureka Road in our system. The demand and order for removal as 1333 Eureka Road, Building 2, that was submitted by Mr. Kohler. But ma'am, your complaint stated 1720. It doesn't appear to have been moved. Although the default judgment shows 1333 Eureka Building 2.
Well, I was going to say, how did Mr. Jones know to go there? Who outlined that or who carried it out? I mean, I don't.
It does not appear as though Mr. Dan Martinez has service of the default judgment. I don't have a proof of mailing by this court to 1333 Eureka Building 2. And the first attempt for service was 1720 Eureka Road. I don't have another attempt for service at the 1333 Eureka Building 2. That's not anywhere in this system, in this file, the paper file at least. And there's nothing in my file system regarding an additional service attempt at 1333.
I got a my file from Carly.
Ma'am, when I ask you to stop interrupting me, ma'am, when I have indicated to stop interrupting me, that's continuing. Please stop interrupting the court. There was after the demand and removal, an order for removal from small claims, it shows that the default judgment was entered by Ms. Schmidtke pursuant to court statute that permits court clerks from entering judgments, defaults. Mr. Kohler, how did you get a copy of the default judgment?
We got it when the court officer showed up at Mr. Martinez's shop and started demanding property or cash. Dan contacted me. I immediately filed the motions that I did.
Okay. Just one moment. I'm going to check something else out and I'll be right back. We're going to go off the record.
Yes, ma'am.
All please rise.
You're doing so good all morning.
I know.
Okay, so we're back on the record in the matter of 2500342. So I stepped off the bench to check with my civil clerk because what I was not seeing was the service attempts for Mr. Martinez at the property at 1333 Eureka Building 2. Because the service attempts at 1720, which is the address supplied by the plaintiff in this matter, was incorrect. And on the affidavit of non-service, it states that Discount Dan Auto Repair is at 1720 Eureka Road, or that the business there is Dan's Auto Repair, not Discount Dan's Auto Repair, which is a different business altogether. So, after that, a default judgment was requested and signed by the general civil clerk, which is permissible pursuant to statute. However, there is zero documentation and there's not any record of any additional service attempts at this defendant's proper address. As such, the court finds that the defendant did not have knowledge and is going to does not have a choice but to set this default judgment aside. So therefore, now you're starting all over. So Mr. Kohler, I'm giving you, you're to submit your answer by July 13th in the appropriate format, counsel, please, not the format that's been put forth in your motions.
Understood, Your Honor.
Once the answer is received, all parties will receive a copy of the scheduling order, which will include dates to exchange discovery as well as participate in mediation. Any questions?
Will the court be assigning the mediator, Your Honor, or should I be finding one?
You all will have to find one.
Okay.
There, you can also, I believe that there's you will receive information regarding online dispute resolution, and you can utilize that as well if you'd like. And also, counsel, I'm going to ask you to please submit an order as to what this court's ordered today, please.
Yes, ma'am.
So to be clear, the entirety of defendant's motion is granted because since the court set aside the default judgment, all enforcement actions are also set aside.
Thank you, Your Honor. I'll
Okay.
submit that later tonight after I get back from Flint.
Thank you. Ms. Latola, do you have any questions?
No.
Okay. All right. Thank you. Have a good day.
Have a blessed day.
First case on the landlord-tenant docket is Equilibrium Management versus Faye Carmouche, file 26-42318-LT. Do we have?
Good afternoon. Yeah, good afternoon, Your Honor. Nicholas Garlinghouse on behalf of plaintiff, filling in for Mr. Whitty today.
Thank you. We have Ms. Carmouche or Michael Workman present. Counsel, what do you want? You want to tell me what's going on with this file?
Yes, Your Honor. This is a kind of an unusual circumstance. It's a termination of tenancy due to damage and health hazard due to violent threats and the defendant apparently attempting to hire someone to kill the landlord. This is also well, there's also another case for non-payment of rent that's apparently set for a trial on the 29th. So with this case, because we don't have a second mailing and I'm not showing personal service, I'd request just a hearing date for this one as well. Possibly if we could do the same time as the other, that might make the most sense.
I don't see how you can get what you're asking for. The only thing that I see on the documentation is that an attempt, I mean, it's bad enough, but attempt to hire someone to kill the property owner. That's not a health hazard to the property. It certainly is to the defendant or to the plaintiff. I get that. But
Yes.
I don't see how I can handle that through a landlord-tenant matter. That's a police matter. That's a PPO matter. But I don't see how it has anything to do with a health hazard involving the building. It's not a feces throughout the building. It's not a dump of oil all over the building. It's not a chemical spill. It's not rats and stuff running all over the place. Tell me, how am I supposed to do something on a landlord-tenant matter where there's a threat to kill somebody?
Well, Your Honor, I would say ongoing violent threats would be something that would be a hazard to someone's health, at least.
True, but it's got nothing to do with the building. The building's not in jeopardy. I can't give you the building because she makes threats to the owner of the building. That's not a landlord-tenant issue. She may need to go to jail. She may need to go to the hospital. I don't know, but I can't give you the building because she makes threats.
If I may speak, Your Honor, under the health hazard code, and we submitted additional documents, we have a approved PPO and there's an ongoing investigation. But under the code, it allows the landlords to file an immediate petition for removal of the property. This affects the landlord's ability to maintain and operate the premise in a safe and useful manner. We can't be on property, and I can't operate it if I have a tenant openly trying to hire people to kill me. So we submitted the PPO. That has been approved. She has been served. It is in effect. She is in the community. And we are allowed to file. This is our way to file for protection against us and our employees, specifically me.
I'm unaware of this provision that you're talking about. So if you want to submit it to me, I'll review it. But my experience in the past and my reading of the statute in the past doesn't allow what you're asking me to do. Personal protection order protects you, the police report and the investigation protects you, but I don't see how giving you the building without any ability for her to address her other issues, which are coming up on June the 29th already anyway. I don't see it, that I have the ability to do that. So if you want to submit whatever documentation that you're referring to, I'd be happy to review it. And if it's as you say it is, then I'll be happy to do what you're asking me to do. I just don't have that thought process in my mind right at the moment. So with that, I'll wait your documentation.
Okay, thank you, Your Honor. We'll get that submitted right away.
Thank you.
Michelle Robinson and Lawrence Kopka, file 26-42320-LT. Who do we have present for that matter, please?
Michelle Robinson.
Thank you. Mr. Kopka, is that you?
Yes, sir.
All right. Have the two of you had an opportunity to try to resolve this matter between yourselves?
Multiple. I would like to state that he has moved out of the house, but he does owe past rent.
What's your plan, Mr. Kopka?
I'm sorry?
What is your plan for resolving this matter with Ms. Robinson?
Well, I've already moved out. I've already vacated it. I've been out of that house for like over a week now. So I don't have any really plans other than move on and have this case dismissed.
Why would the case be dismissed if you owe her back rent?
Well, during the last few months, she told me not to worry about paying for rent and to focus on finding a place to live. And that's what I've been doing for the past few months. And I have finally found a place to actually live, so I have already moved out.
Mr. Kopka, are you really trying to tell me that a landlord told you you didn't have to pay rent?
Yes, sir. That was a couple of months ago when she was fighting with my mother. There was a bunch of family drama going on, and that's what how we came to here. It was a family fight that I got dragged into.
Ms. Robinson, any response?
I served him a 7-day notice to pay by April 15th. If not, he had to leave. And he left and he came back and never paid. Like, I figured that I told him he could find somewhere else to live or he could pay.
Did you tell him at some point that he didn't have to pay?
No, I did not. He should have paid for April, May, and June, not including all the other old payments that he's paid every time late with late fees.
So how much are you claiming that he owes?
With the room rent 500, 1,700, and with the increased room rent for him being late every time and not paying on time is $2,800.
So didn't pay at the $500 a month rate for a little over 3 months, and he didn't pay at the $700 rate for 4 months?
Yes. He lost February.
I'm sorry.
Oh, sorry.
Go ahead.
He lost his job in February, and he acknowledged that he hasn't been paying, and I told him even though he lost his jobs, he still has to pay.
So the 1,700 came before February and the 2,800 came after February?
Yes.
Does that sound about right, Mr. Kopka?
No, sir, it does not.
Why not? Why not?
Well, back in April, she was actually harassing my mother and causing fights with my brother to the point where, because my mother was living with me, and to the point where my mother moved out to get away from her, which to the point she was harassing me and trying to pick fights with me, to the point where she apologized and said, "Don't worry about moving out. You can stay there for right now, and then you don't have to pay until you can find a place and save your money until you can find a place." And that was in April. My mother even had to call the police over how distressed she was from my Michelle, my niece, coming over to the house and antagonizing and looking for ways to instigate. And this has been going on for about the past 2 months.
Mr. Kopka, how is what you've just told me a legal defense for not paying your rent?
Well, that's what I was just telling you. She told me back in April. She told me not to worry about it because she wanted me to go find a place to live, and that's what I was doing. And then it's been taking me a couple months to find a place because there hasn't been very much available.
Mr. Kopka, how many places have you rented in your life?
Maybe one. Maybe actually one that was actually on a lease.
So one in addition to this one?
No.
So this is the only place that you've ever rented in your entire life?
This place? No. She didn't even have me on a lease.
That wasn't my question. I asked you how many places that you've rented in your life?
One.
All right. Did you get to leave or stay there and not pay rent for any part of the time that you stayed there?
At this current address, yes, I did pay
No,
rent
but your
there.
the previous one.
Yes, sir, I did.
Well, you got to be the luckiest man in the world then, because that's not how the real world works. If you stay at somebody's house or staying in their building, you're paying rent for it. You don't get to stay there for free.
I'm confused. What place are we talking about for free? Are we talking about the place that I used to live at, or are we talking about this current place?
Any of them. Why in the world would you think that you get to stay at somebody's house for free when they're trying to get rent for it?
I didn't. She told me to not worry about rent and just to continue to hold on to my money to save to find a place. And that was
Why
back
would
in
she want
April.
to do that if she's trying to get rent?
Because I have been staying there for the past few months trying to find a place without paying for rent because she told me not to worry about it.
That's circular reasoning, Mr. Kopka. I asked you why. You just went around in a circle. You said because she said so, and it's because she said so. Why would anybody do that?
Well, one, because we're a family, and I was thinking that she was doing something that was family related and doing me a favor by letting me continue to stay there and while I looked for a place and saved my money.
So what are you going to do about all the rent that you didn't pay before April?
She didn't tell me I had to pay for it. She's now just saying it. Now she's saying it now. She never said anything about it the entire time. The entire time she's been telling me to get out of the house. I'm sorry, sir. I don't know what answer you're looking for.
Ms. Robinson, when did he start living in your house, and how long are you paying, charging him for rent at the $500 level?
And exhibit number 2, he moved in. Well, I messaged him April or September 6th. He had to pay $500 for his room. I let my grandma live there. I was going to take care of her, and Jacob was living with her for free. He just tagged along and moved in later.
So exhibit number 2 is a
messages of our verbal agreement of $500 a month.
Is that true, Mr. Kopka?
Yes, it's on Facebook.
Yes.
Anyway,
Mr. Kopka, so she told you that you owed $500 a month in September, right?
Yes.
Starting in September, and how long was he in there for the $500 a month?
Until February, and I told him in February that it was going up on exhibit number 4, February 3rd, that would be going up in March. And he got fired February 16th, and I don't know if I put it in here.
Laid off.
Exhibit number 5, messaged him. I said, I understand you got laid off, but my stipulation for the amount of room and board stands, nothing has changed, $700 on March 1st.
Is that true, Mr. Kopka?
I'm sorry, I didn't hear what she said.
She said in February, she sent you an email or a message that said rent is now $700 a month. And that's exhibit number 4, the rent increase, and also exhibit number 5, which reminded you that the full amount is due on the 1st, and room and board went up to $700.
Yes. Around between January and February, I did get laid off, and I was filed for unemployment, and I've been collecting unemployment since. And I even offered to continue paying her rent.
Doesn't sound to me like you continue to pay anything.
Yeah, I understand that, sir, and I keep telling her. Back in April, she told me not to worry about it, and that just save my money so I can find a place to move out.
Okay, stop repeating the same thing over and over. I've heard it 4 times. My question is, before April, what are you going to do about the payments before April?
Before April? Well, I already assumed that my mother already paid some of that off because she was actually covering my side of the rent. How much she paid, I don't know. We would have to ask my mother.
How old are you, sir? Mr.
Right
Kopka,
now,
how old are you?
I'm 38.
Good Lord, man. Ms. Robinson, is there anything else that you want to tell me?
Um, I'd like to state that he took my TV out of my house, but I'm not too worried about it. But I want him to know that that wasn't his to take.
Claiming the television or not? Do you want to make a claim? You want him to pay you back for the television or not?
No, that it's old and I don't even know. They would. I've had that TV since 2017. But just the simple fact that it was not his right to take.
All right, so you're asking me for $4,500 on a judgment?
Yes. And possibly more due to the cat urine in my house. I don't know how expensive that's gonna keep. I apologize.
Well, he's been out since April. Have you got it cleaned since then?
No, I was waiting until after the court hearing. And I've already paid for a dumpster the first time when my grandma moved out, that Jacob, we had a really hard time with him using a free dumpster, taking the trash to the dumpster. So me and my boyfriend would always come over there and take care of the trash because they would just trash everywhere. So we're going to have to pay more money to get a dumpster to take care of the stuff that's left behind. And the carpet.
That's not true. I cleaned, that house was cleaned when I left. My sister was even there to clean it with me. So that house was actually very clean.
You're out of the house now, Mr. Kopka, is that correct?
Yes, sir, I am. Right now, I'm just struggling trying to find work.
All right, I'm going to find that the defendant may be liable for money damages after moving if additional rent is owed or if there is damage to the property. Acceptance of partial payment will not prevent the court from issuing an order of eviction because he's already removed. Ms. Robinson, did you incur costs of $55 for filing, service fee of $38.18?
I did not. And it costed $30 to send proof and about $100 in the library for all the paperwork I had to prepare.
What was your cost for filing this with the court? That's what I was asking.
Oh, I'm sorry. It was $55. And then the delivery from the sheriff's was $37.18, I believe.
Yeah, $38.18 is what they have noted on their document. So I'll give you that. I can't give you the $100 for the copying cost. That's on you.
Okay.
I can give you those other costs.
I'm not sure if you had a chance to look through all the pictures that I submitted.
I did.
And so that amount of garbage that was outside when my grandma had left was my grandma's stuff and Jacob's stuff. And all that we had taken care of. And now we have to go back and clean the house. And I need to replace all the carpets. It smells like cat piss and cigarettes in there. And I wanted to also include here that there was no smoking in the house or at the house, and Jacob had violated that several times.
That's not true. There's an ashtray outside that proves that there has been cigarette butts all in that ashtray. I smoked outside and only outside. It was everybody else who was coming in and out of that house when my mom was living there.
In one of the text messages says absolutely no smoking in the house and more talk about that. And I believe there was another one on here that smoking and cigarette butts being thrown on the ground. To ask him, all your cigarette on exhibit number 5, third, I said, all your cigarette to be thrown away properly. My porch is not a trash can.
Here's what we're doing. I'm going to give Ms. Robinson a total of $4,500 for back rent. Costs in the amount of $93.18 for a total of $4,593.18. I'm also going to enter a further order that says that she may reopen the case if additional cleaning costs are incurred. Mr. Kopka, you may contest whatever those cleaning costs are if you don't believe that they are accurate or required. So we'll have a further hearing on that if you guys can't reach an agreement on that. Mr. Kopka, I got to tell you, at 38 years old, trying to rip off your family by living with your grandma and then living with other members of the family.
I'm sorry,
Stop.
but I don't.
This is my time to talk, not yours.
I understand that, but I mean,
no, there's no but.
I'm not taking advantage of anybody.
Hey, another word and it costs you $50 in court contempt charges. Do you understand what I just said to you?
Yep.
I don't believe you when you tell me that she said you didn't have to pay any rent. That's wishful thinking at the very best. Get a job, live on your own, pay your own way, stop soaking up other people's stuff. And you can get a copy of this judgment from the court. Talk to Ms. Good.
Your Honor.
Yes.
I did get a quote from Maid Pro to see how much it cost for them to come clean my house and try to.
Well, let's just do it once it's done. So whatever it costs you, keep track of it, submit it to him first. If he doesn't pay it within a reasonable amount of time, you'll be able to submit it. I've put in here that you can reopen this case under the same heading, so you don't have to file a whole new request. But you may have to send a request into the court to Ms. Good to remind her of that so she pulls this case. But file it under the same heading, the same case number, and ask for additional costs. And we'll pull the file and take a look at it then. That'll be the order of the court.
Thank you, Your Honor.
Both are free to go.
Thank you.
All right, the last case on the landlord-tenant docket is Michaela Moore and Austin May, file 26-42091-GZ. Who do we have present for that matter, please?
I'm here, Your Honor.
Do you see Ms.
Michaela
Moore?
Moore.
Thank you. Do we have Austin May with us?
Yes, sir. Sorry, I thought I unmuted.
That's all right. Thank you very much. This is an action involving a 2002 GMC Sierra truck. And I believe Ms. May has filed a motion for possession of that. Ms. Moore, you want to go ahead and tell me what it is that you want me to do and why?
I would like his name to be removed off the title and for me to get my truck back. Because like I said last time, he has only made those 2 payments. He has still not put that money into my account like you had asked him to last time. We've tried meeting up, but every time it happens, something either happens or he ain't getting a hold of me when he gets out of work. When he says he will. And I currently don't have my truck at the moment. It's been in the shop. And I need a vehicle for work.
Mr. May, what's your response?
Your Honor, I've been getting out of work at 7 o'clock, so I haven't been able to meet her because she's been wanting to meet at 4. Meanwhile, trying to meet, I've been getting, nasty voicemails with death threats. Deputy Booten was involved. It's been an ongoing case. He told me to meet her at the police station, and she doesn't want to do that. Also went to make a payment to the mechanic. He told him the situation with the truck in court, and now he put a lien on the truck.
Could the two of you make this any more difficult?
I'm not trying to be, Your Honor.
Well, how many days a week do you work?
Almost every day, other than the weekends.
Well, there you go. Why didn't you contact her on the weekends and say, I got this time on the weekend to meet?
She doesn't want to meet at the police station, Your Honor.
Your Honor, I work every other weekend. And when he tried meeting up, I was stuck at work. And I did try getting him to meet me at the bank, and Nothing, no.
Would it be fair to say that the both of you want this issue resolved?
Yes, Your Honor.
Yes, Your Honor.
Well, then why don't you act like it? Because neither one of you is making it easy to resolve this. You're not making time for the other person. You want it to be easy for you and make the other person jump through the hoops. That tells me you're not trying to resolve the matter. You're trying to get back at the other person. That's how 4-year-olds resolve problems. You made me mad, so I'm going to make you mad. And I'm not going to do anything that you want to do because I don't want you to have anything that you can get out of this. So if you really want the truck to be resolved, you would meet, whether you had work or not. You'd figure out a day and a time to get together and you'd do a business transaction and you would resolve the problem. But the two of you don't. You're not fighting about the truck. You're fighting with each other.
Your Honor,
So here I am. No. I'm not asking you a question. Here I am stuck trying to resolve things that the two of you as adult human beings should have the brain power and the ability to deal with. I don't have any doubt in my mind that if you two sat down together, you could figure this out. This is not rocket science. But it just means that you got to put away your personal feelings and do it. So how long is it going to take you to do that? Because I'm not going to do it for you. You guys got to learn how to be adults. So when are you going to meet and how are you going to do it? Ms. Moore, what's your suggestion?
I don't think they're gonna be resolving it because he wants the truck and I want it. I paid almost $3,000 on it. I only owe $1,800.
I didn't ask you to convince me. I did not ask you to convince me of your rightness. I asked, how are you going to resolve this problem with him? This is a business transaction. You paid some money for a truck. You want your truck. He says something else. How are you going to resolve this problem? That's what I want to know. I don't want you to make your closing argument. I want you to figure out how to resolve something with somebody else. And then, hey, Mr. May.
Yes, Your Honor.
Don't give me any crap about a gift.
Yes, Your Honor.
That's a non-starter. You have to come up with a plan to resolve this. You're either going to buy that truck from her or you're going to do something else, but the two of you are going to resolve this issue.
Yes.
This is what adults do. They figure out how to resolve an issue. So I'm going to come back to Ms. Moore. What's your plan for resolving this issue?
Me, I can meet this weekend and I can throw her some money. I mean, I'm willing to pay. I got the money this weekend.
Good. Ms. Moore, what's wrong with meeting this weekend and trying to figure things out?
I work 8 to 8 this weekend.
When are you open then? When's the next date that you have available?
I won't know that until tomorrow when my next schedule comes out.
Are you scheduled typically to work 2 weekends in a row?
No.
Then probably the weekend after that. You're available, Mr. May, the weekend after this?
Yes, Your Honor.
So today's the 15th. This coming weekend is the 20th and the 21st. So we're looking at the 27th and the 28th. You guys can meet on the 27th or 28th, right?
Yep. Yes, Your Honor.
Yes, Your Honor.
All right. I'm going to hold you to it. We're going to come back here on July 13th. I don't have one the next weekend after you meet, but the Monday after that, the July 13th, 2:15. You guys are going to tell me what you did and how you did it and how you resolved this matter. If you can't resolve it, I'm going to read you the riot act all over again in front of everybody. Okay? And then I'll decide what to do after that, but it's not going to be pretty. You understand what I'm telling you? This is on you. This is your responsibility as an adult.
Yes, Your
Figure
Honor.
out a way to resolve this matter. Meet sometime on June 27th or 28th, and then you got to explain if you reach an agreement. Ms. Moore, since you're the plaintiff, type it up, send it into the court, and we'll be done with the case.
Okay.
I'll order what you guys agree to. If you can't reach an agreement, I'll see you on July 13th at 2:15 via Zoom, and be prepared.
Yes, Your Honor.
Yes, Your Honor.
All right, see you then.
Thanks.
Thank you, bye.
So what we'll do next is I'm going to go over for the parties that are present in the cases that will be heard today. What I'm going to do is I'm going to start by going through the legal definition of unlawful harassment. And the reason I like to start these hearings that way is because we use terms like harassment and stalking and things of that nature in everyday parlance fairly frequently. And there's a legal definition, though, that needs to be satisfied in order for the court to issue an anti-harassment protection order. And so what I'd like to do to set the tone for these hearings and to let everyone know what I'll be looking for from the judicial perspective is I'm going to go through the 6 elements of unlawful harassment. And in these hearings, the burden is on the petitioner to prove each of these 6 elements by what we call preponderance of the evidence. That's a fancy way of saying more likely than not. So each of these 6 things need to be shown more likely than not based on the evidence. The evidence being what was submitted in the petitions, as well as sworn testimony that we'll hear today. So those 6 elements are as follows. The first is a knowing and willful course of conduct. What that means is, with very limited exceptions, unlawful harassment legally only occurs if there's an ongoing pattern of behavior, a course of conduct that evidences some sort of ongoing purpose, not a one-off situation that left you feeling uncomfortable or even harassed. Again, that may be the case in very limited circumstances, but generally speaking, we need a pattern of behavior. That pattern of behavior, that course of conduct, number 2, needs to be directed at a specific person. Number 3, without a lawful or legitimate purpose. And what we mean here is that the conduct, we look at things like, was the conduct initiated by the respondent or by the petitioner or by both parties, who sort of engaged first in the conduct leading to the petition? Has the respondent been given clear notice that further contact with the petitioner is unwanted, but that contact persists? Does the behavior have the purpose or the effect of interfering with the petitioner's privacy to an unreasonable degree? Does it create an intimidating, hostile, or offensive living environment? So we look at the purpose behind that, the conduct that's at the basis of the petition to see if was it legitimate or illegitimate or unlawful. So that's number 3. Number 4 is whether or not the conduct appears designed to alarm, annoy, or harass the petitioner. And I like to take a moment here on this. That is an element in the statute, that whether the behavior appears designed to alarm, annoy, or harass the petitioner. But it's also the case that even if I've yet to come across someone who intends to harass someone else. There's usually somebody is subjectively thinking what they're doing is fine, but it's being perceived by the other party as harassment. And so, I like to point out that if you're the respondent here, just because it's the case that you didn't intend necessarily to harass the other side, does the conduct appear designed to alarm, annoy, or harass? So in other words, looking at it objectively, from not from necessarily a subjective point of view, but an objective point of view, what does this behavior look like? Number 5, the behavior or the conduct would cause a reasonable person to suffer substantial emotional distress. So here we're looking at, again, objectively, is the conduct we're talking about here, even if it meets all those other definitions, would a reasonable person suffer substantial emotional distress because of it? And then finally, does the petitioner subjectively actually suffer substantial emotional distress? So it has to be substantial emotional distress that the petitioner actually feels, and that feeling is reasonable. So again, those are the 6 elements. I'll run through them one more time without all that extra commentary. Knowing and willful course of conduct, directed at a specific person without a lawful or legitimate purpose that appears designed to alarm, annoy, or harass the petitioner, that would cause a reasonable person to suffer substantial emotional distress. And it actually does cause the petitioner to suffer emotional distress, substantial emotional distress. So that's the definition of unlawful harassment. So again, those are the elements that I'll be looking for, because each needs to be proven by more likely than not a preponderance of the evidence in order for the court to take any action and issue an order. What's going to happen procedurally is I'll call the case, and then everyone is on Zoom whose cases are going today, so nobody will call it to a table. But what I'll do is I will put both parties under oath. So when you testify today, you're doing so under oath. And so it's critical, and you then have a legal obligation to tell the truth. I'll hear first from the petitioner, and then I'll hear from the respondent. I'll also hear from either party's attorney. I know Mr. Zeller here has counsel, so I'll hear from Ms. Cruz. And then I'll make a decision. And so the decision will be based again on the testimony that I hear today, as well as what's been filed in the petition and the exhibits. And then I'll make a decision. Before I take testimony, what I like to do too is provide a brief sort of bird's eye view summary of the allegations and the responses. That way, the parties all know where I'm coming from. You get a sense that I've reviewed the materials, and you get a sense of what I've taken from those materials. So that way, when you testify, you're able to fill in the gaps, correct me if I misunderstand something, that sort of thing. The last thing I'll say today is to direct all of your comments towards me. These hearings are sort of inherently uncomfortable, and you will hear things when the other side is testifying that you vehemently disagree with, and that might make you frustrated and angry. I understand that, but you are in court. Even if you're appearing remotely, you are in court, and so direct all comments at me. Don't start talking to the other side. Don't interrupt the other side. Again, remember who's the decision maker. And if I perceive that you're sort of getting out of hand and yelling and trying to interrupt the other side, that's probably not going to help your case. So these are uncomfortable, difficult situations. Try to keep a cool head while you're testifying, and direct your comments all towards me. All right. Court's ready to call matter 26-246. All right, we've got Mr. McAdams present. And do we have Ms. Molina?
Yes, I'm here.
Give me a moment, folks, while I bring up your file. All right. Okay. So similar with the other case, what I'm going to do first is review my understanding of the record, and then I'll swear in Mr. McAdams as the petitioner, hear from him, then swear in Ms. Molina, hear from her, and then make a decision. All right. So the parties here sounds like are former dating relationship, never have lived together. Mr. McAdams has alleged that Ms. Molina, among other things, has threatened himself, his children, and their children's mother. And it looks like there's three children there who are listed in the petition. As evidence, Mr. McAdams has uploaded dozens of text messages between the two. Part of the allegations includes after they concluded dating, Mr. McAdams alleges that he had told Ms. Molina he didn't want any further contact, but there was persistent contact after that from different social media accounts, primarily. And again, as part of that too, threats to his children and his children's mother. I have not seen anything in response from Miss Molina. Nothing's in the court file. So before I swear in the parties, Mr. McAdams, I've had a chance to review the exhibits, including the handwritten summaries that you provided, as well as the text messages. One thing that I'd like you to maybe point me to is I was on the lookout for the text or anything to substantiate the threats specifically to you and your children. I wasn't seeing it in the exhibit, so maybe you could help point me in that direction as part of your testimony. And I do have your exhibits up, and so if you have those handy, feel free to kind of point me to those. And if you want to just address that as well, you did make those statements in your petition that these threats have been made. More context on those, I think, is important, because as I said in the beginning, it is your burden to show that the conduct occurred that it's more likely than not that the conduct occurred. I think that will be important for you to kind of flesh out a bit. The allegations are there. I didn't really see it in the exhibits that you uploaded. But with that, sir, I'll stop and let you actually testify. So if you could please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
Yes, Your Honor, I do.
Go ahead.
So, when it comes to the threats of my children, my ex-wife, her wife, and me, when it comes to the threats of my children, my ex-wife and her wife, I had received a screenshot that I had presented of her and my ex-wife arguing, fighting, and she had stated that she doesn't have to fight. She is willing to shoot. She has mentioned to me about her trip coming up of her going to Texas, Connecticut, and one other place I can't remember to visit family. And I have been told that she has even resorted to going to New York, where my 3 children are, to physically harm them. I have not gotten any evidence of her actually saying she's going to New York to do it. I only got the one screenshot I presented you of her threatening my children by saying she's going to shoot their mother or their mother's wife, or possibly them. Then when it comes to her threatening me, myself, I presented quite a few different screenshots. There's ones from a friend threatening me coming to my work. There was an incident in April where me and her were talking and still trying to work on our relationship. And her and her friend came to my work, was holding hands, acted like they were in a relationship. She had told me that that was not the case, that she just wanted me to feel hurt. And I had, out of emotions and being hurt, I took a photo of them holding hands, sent it to her, asked her what it was about. She had told me that it was just to get me hurt and that she was going to take it to my managers and try to get me fired. I had talked to my management, my secondary security that we have, or asset protection security we have at Walmart about it and everything. And I had shown them the screenshots, messages, and everything. And then about a week later, she had came to my work. We had talked during my lunch, thought everything was going good. She had stated that she had, for 3 days beforehand, planned on leaving me and didn't explain what was going on, why she felt that way when everything seemed like it was going great. And then after she had said that, I was angry. So I took and had an empty can of soda, and it bounced off her seat and hit her like on the side area. And then she had later on had the Lacey Police Department come. They had talked to me, asked for a statement. I explained to them what happened. They said they had gone across the street, talked to her, and everything. She wasn't there. Then later on, she messaged me saying she had talked to police officers, claimed she had a red mark on her face. So then I had called the same officer back because she gave me her card with her number and name. And she had stated that when they finally went over there, was able to talk to her, that she did not have a red mark on her face or any bruises or anything like that. Then couple weeks later, after we fixed our relationship and everything was going all right, I had a gut instinct in my feeling that Miss Melina was possibly talking to somebody else or cheating or something. And we had a couple times I had allowed her to go through my phone, or she's gone through my phone when I was sleeping. And during this time, I had the gut instinct that maybe I should go through her phone, see if she's talking to the guy I was worried about. And that when I did that, I found out she was indeed talking to that guy. And then she was sexually texting a coworker after she was only at work for one day. And then
so Mr. McAdams, I'm gonna stop you. So, one thing that this process doesn't address is issues with a relationship, infidelity, why somebody might cheat on someone else, doing things like parading around another guy at your work to make you feel hurt. None of that is relevant to anti-harassment orders. I understand that's not to belittle how that might make you feel, or anything like that. I'm sure that that's a hard thing to go through. But what we're here to assess is specifically the unlawful harassment piece. And so I want to make sure we stay focused on that. And I do have, as you've been talking, I've been listening, but at the same time, I've been going through the texts, and I am, I'm trying to find, so maybe you could use your time to also help me find the texts where there's the, I don't have to fight, I just have to shoot statement. And then if you could also maybe talk more about where hang on. And then also I'd like to hear a little bit more about your belief that she's going to New York to harm your children, and kind of why you believe that's a credible threat. So those two things, if you could point me in the direction of that, I don't have to fight, I just have to shoot, and then information about traveling to New York to harm your children, why you think that's credible. So I'll send it back to you, but those are important parts. And then at the same time, so Ms. Molina, I've kind of been seeing you in and out here. It's important that you stay present here, because while we allow remote testimony and remote appearances, you are in court. And so if you keep leaving like that, I don't know if you're here. And so, I'm not going to be able to hear from you if you're not present. Okay, go ahead, Mr. McAdams.
All right, so I have a screenshot I presented you. I can't remember what day she had sent that message to my kids' mom. But it's just a quick little message of them arguing, saying that she doesn't have to fight, she can shoot. That's the only thing I've gotten from them about her threat towards my ex-wife and my 3 children. Apparently she had told them at some point, I don't know when, but I do know Miss Melina has stated to me personally when we was together that she does plan on going to visit her family in Texas and a couple other states. but I don't know if it is factual that she plans on going to New York to take and go after my children. But I am afraid that that is a possibility due to the fact of her threats towards me and her coming to my job and almost making me lose my job twice.
All right. And thank you, sir. So, Ms. Molina, we've got you here. I need you to try and stay put. You are in court. I know you're appearing remotely, but we need you to kind of stay put and participate in the hearing here. And we're going to turn to you next. I'm not going to have Mr. McAdams go back over anything you may have missed. So, all right, Mr. McAdams, anything further, sir, before I turn it over to Ms. Molina?
The only thing else I would like to bring up is possibly talk about the false allegations that she has accused me of hurting her 6-month-old child that she has shown on during this time. She had accused me of physically abusing her, the baby, and tried to claim that I was covering his mouth up when I had been in his life after he's only been a month old. I've been a father figure to him. She has stated that to me, her family, her friends, and everything due to the fact that his own father has been in jail since July and her other kids' dad is around him all the time. But because I would spend time with him, I would play with him, I would try to take care of him and everything, there's no proof or evidence of me hurting that child and everything.
All right, thank you. And I did see so was that the CPO investigation or the DCYF investigation, the documents you uploaded, where there was a finding of unsubstantial evidence?
No, that one was due to the fact that Ms. Molina had brought up a questionable or a statement from her that I guess she had talked to my ex-wife about a past case of my autistic son, who at the time I had moved out of my ex-wife and my apartment into a new apartment, and I did not have the money because of moving to get a lock or any way to keep him from being able to open the door to leave. And there was 2 times within a small amount of time that when I was asleep and I had woken up, that my oldest son and my daughter was right next to me, and I was looking for him, and I found out he was downstairs because I was on the 2nd floor, and the police had him right there. And I told him thank you. Ooh, I explained to him what happened. They understood. Then the 2nd time, I found out he was at Safeway, which is right down the road from where I lived at and currently live at, because it's basically right my backyard, and everything. Because I'm not used to taking care of a special needs autistic child like that and everything. But over the years, I have tried my best to take care of my kids when I did have them. So my ex-wife had accused me of neglect and abuse to my children, also because there was one time that my daughter had gone from my place to back home to hers, but my mom was watching my kids a couple times, so because I was on overnights, so I needed rest. She would watch them for a little bit. Then when I wake up, I'd take care of them before I sent them back home. And there was a bruise on my daughter's inner thigh that was unexplainable. All I could think is maybe she got hurt from her and boys roughhousing, or maybe fell or something. I wasn't 100% sure how she got that bruise because I didn't know about it until my ex-wife had told me. Then she had called CPS for neglect and abuse. They came to my house, interviewed me, my oldest son. They had stated in that statement I have handed you that there was no proof of evidence of neglect or abuse. When we went to court, I had let the judge and everybody know when it came to disciplining my children, I did in fact use a belt on my children, but it was very rarely. I would talk to them, let them know what's wrong. They explain to them, hey, this is why you can't do that and everything, before I had let them know that, hey, you did this. I already explained to you one time. You're not supposed to do it. I'm going to explain to you again. This is why you don't do it. And then spank the butt one time, and that was it.
Okay. All right. Thank you, Mr. McAdams. Anything else on with respect to your petition before I turn it over to Ms. Molina?
I know there's one paper I'm not sure if you're worried about dealing with the fact Miss Molina has pointed out now twice that she had ended up pregnant by me, and I had turned in a statement from the vasectomy place showing that there has never not been any sperm or anything validating that if she was pregnant, that was guaranteed to be mine. I had that vasectomy.
Yeah, Mr. McAdams, I read
4 or
those
5
two.
years ago.
Yeah, no, I don't have any questions about those. I did have a chance to review all that paperwork as well.
All right, then that's everything, Your Honor.
All right, thank you, Mr. McAdams. All right, Ms. Molina, this will be your chance to respond. If you could please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
Yes.
Okay. And then before you do respond, I think I found the screenshot that Mr. McAdams here was referencing, where again, this is your chance to sort of correct me if I'm wrong here. I think it's a text messages between you and Mr. McAdams' ex-wife, indicating, I don't gotta fight. I can just shoot. And there's a response about that statement getting you in trouble. And there's, kind of back and forth, but I think that's kind of what he's talking about there. So, that's obviously concerning. And so I'll give you a chance though to respond. I do think I have that up now. But go ahead. This is your chance to respond to the allegations in the petition. Again, I know there's some things raised about, not asking you to go into allegations of cheating or getting back at each other in a relationship or things like that. Specifically what I want to hear more about is allegations of, threats to shoot and allegations of going to New York to harm Mr. McAdams' children. So those are the primary allegations in the petition that I'm concerned about. So this is your chance to respond to those.
Okay. So, I don't even know where to begin with this, but those are things that out of just complete, those were never actual like threats. His kids' mom had sent about 600 messages, voice messages, phone calls, text messages. It had gone on for about 4 days in a row, to the point where she's like, I got your address now. And she told me that she had my address. I had confirmed with Mr. McAdams.
Ms. Molina, when you're saying she, who are we talking about?
His ex-wife. Stephanie.
Okay. Thank you.
Yeah, Stephanie and her wife currently had sent me voice messages, called my phone. They had made 2 different Facebooks to stalk and call my phone and send me messages. I can bring in proof of all the things. He had sat outside my home unwarranted, unwanted, unneeded outside of my house. I have pictures of him sitting outside of my home. We weren't together. We weren't together either when I walked through the Walmart. We weren't trying to fix our relationship. We were talking as friends. I walked through the Walmart and he followed behind me. And then it occurred to him sitting outside of my home, taking pictures, and him sending those to his kids' mom as well. I have all the proof of that. Like, yes, there was threats, but it was because he would not stop sending people after me. He would not stop giving out information about me, and my personal life, threatening me and my kids, my home, telling people where I lived. I have staff members here and my kids' father that can account for a time where he stood outside of my apartment building, screaming and banging and yelling on the doors downstairs because you can't get up to my apartment unit. There's locked doors downstairs, screaming for his stuff back that I told him I wasn't home and able to give it to him at the time. And he continued to scream and yell and tell me I had to give it to him right then, causing an issue with my apartments that I had to deal with. And then anytime we have never spoken, I've never shown up to his work. It's Lacey Walmart. It's the Walmart I prefer to go to. But since me and him have not spoken in 2 months,
a month and a half. I have not spoken with him. However, his kids' mother, his friend, they have constantly reached out to me. The most recent message being about a week ago from his friend telling me that if this is who it actually is, then you need to leave me alone. And that was to my Facebook, that I needed to leave their stuff alone. They have been blocked on all my pages for the time we haven't spoke. I've been focusing on work with my kids, and I have put, every time we have stopped talking, he has sent people after me. He has messaged me. He has come in after attacks. I have proof of pretty much everything I'm saying. And I could show my side too, where I wasn't very nice when it came to it. And, but the threats were never intentionalized. It was, please stop harassing me, or this can happen. I'm a felon. I don't have gun rights. I've never shot a gun in my life. There's no shooting. It's always fighting. So I don't know when or where it's thrown in.
When you're talking about the threats and all of that, are you talking about, is that to Mr. McAdams or Mr. McAdams' ex-wife?
There is threats from both sides, and I've only ever threatened him. I've never threatened her or their kids. I don't even know their kids' names or where they live in New York. I don't know what city in New York. My plans are to go to Texas to visit family, not wherever. New York is completely away from Texas.
All right.
My friends also say that he drives past them every day. And then I have seen him multiple times past my work. I work downtown, and multiple times I've seen his vehicle take a turn past my job, which is out of the direction of, why are you coming out of your direction if you're passing my friends and then turning towards my work?
All right. Thank you, Ms. Molina. I have one more round of questions. This is for Mr. McAdams. I know I've kind of focused on the threats to the kids and the ex-wife. Part of your petition too is that you told Ms. Molina to stop contacting you, and then there was persistent communication after that. It's a little hard from the text messages to get a sense of the timeline. I know there's a lot of, on both ends, I think, blocking each other, unblocking each other, things of that nature. Are you able to testify as to a time when, you had told Ms. Molina you did not want to talk to her anymore, you didn't want any more communication, and then she kept contacting you after that? In the context of, you never then unblocked her, you didn't re-engage her in communication, but was there a point in time when you told her, I don't want any more contact, and then she persisted, and then you filed for the protection order?
Yes, Your Honor. The moment I had left Miss Molina's house, I had gotten on the phone with my ex-wife to try to fix an issue between both of them, talking about reporting each other's Facebooks because they have personal reasons why they don't want them deleted and everything. And Miss Molina had kept blowing up my phone, accused me of cheating and stuff later on. And I told her I don't want nothing to do with her due to the fact of finding out she was messaging her coworker and the guy that's her friend's, one of her friends that happens to be her oldest son's dad's best friend and everything. I had told her I don't want nothing, no contact, nothing to do with her, that I want to move on with my life. Then that's when I had received all the messages and screenshots that I had provided.
Okay, so what's the timeline here? So when
accounts
that she, what was the timeline? So when did you say, I don't want any more communication from her?
It'd be at the beginning of May, like when I left her house. So I want to say maybe this first or second, not really sure exactly which day it was that I had left her house because it's been a while.
So this was early May?
But the moment I left her house and everything.
Okay. So you're saying since May,
either first or second.
So you're saying since early May, you've told her you don't want any contact, but she's kept sending you messages?
Yes, but there was one time that she had asked me to contact her and go ahead and have my phone number blocked where she couldn't have it due to the fact that I had my phone number changed twice, so that way she could not contact me. And so I reached out like she had asked, and I had asked her nicely, if I'm going to reach out, can you at least apologize for your false allegations, knowing that I would not hurt her or hurt the baby. And that was it. And she didn't want to apologize and everything. So then I told her, okay, then, and there's no reason for me to talk to you because that's what I was hoping for is an apology for those false allegations that she knows ain't true and everything. So then after that,
And so
I have not
when about
contacted her once since.
When about was that?
Wasn't too long after that, so maybe the 4th or 5th, somewhere around there.
Of May?
Yes, sir.
All right. And then so after that, after you're saying she didn't apologize, has there been contact from her after that?
The only contact that I have not contacted her myself. I have not seen her try to contact me directly. I did receive screenshots that she had gone on to one of those fake accounts after the day after she had received this restraining order served to her, that she had went on and posted on her story on their fake account of claiming that she was going to go put a restraining order against me, claiming everything I had turned in to the court is lies and false allegations and everything, talking about some of the screenshots and stuff, like the pictures of me outside of her house, saying that I was stalking and harassing her during that time, when those photos were taken due to the fact that I was trying to reach out and fix the relationship during that time. And I had messaged her, let her know, hey, I am downstairs, I am outside. I had bought her some stuff that I knew she would like, and I was trying to give it to her. And then I wanted to take her out and surprise her for breakfast before I had to head to work for a early shift that day, because usually my shifts like 1 in the afternoon to 10 at night. But that day I was scheduled a morning shift due to the fact of people's hours being cut and switched. So I wanted to show her that I was willing to put in more effort.
Or about when
that
was
would
that?
be that would have been like in April, like towards the end of April.
All right. Okay. All right. Thank you. All right. So since you you'd wanted her to apologize and she indicated she wasn't going to, sounds like there hasn't been any direct communication, but you were able to see through one of her social media accounts that she kind of posting about wanting to file her own order and things of that nature against you.
Yes.
Based on some. Okay. All right. Okay.
Yeah, and that's when I found out she had stated about me harassing her friends for my drive to work, because the way I go to work from the west side of Olympia, I go through downtown and I could go straight forward, which is what I've done for 3-4 years and everything. Her friends hang out on the side of a street next to a store, so there's nothing I can do about that. Me turning to go past her work and then turning in past the front of her work to go to the freeway, I've only done that due to the fact the kindness of Miss Melina's heart when we was together, that she had shown me I can take that way to the freeway and everything. And since she had shown me that way, that's the way I was going. But since I had found out that she is saying that's a problem, I have gone a different way to get to the freeway, so that way it's not an issue no more.
All right.
Because I usually don't drive on the freeway until Miss Melina had shown me that route.
All right. Okay. Thank you, Mr. McAdams. I appreciate your testimony. Ms. Molina, I appreciate yours as well. And, you know, it sounds like there's a lot of really strong feelings on both sides and a lot of pretty complicated relationships involving both all of you, but it sounds like some other folks in your communities as well. And I don't want to at all diminish what you all might be going through. At this time, though, I don't find that there's sufficient evidence for the court to get involved and issue an anti-harassment no contact order. The two things that I was looking for Mr. McAdams' petition, number one is if that course of conduct of Ms. Molina continuing direct communication, direct or third party or indirect communication back to Mr. McAdams after that sort of unequivocal notice to her that he doesn't want any further contact. And I think that message being unequivocal is really important to me in this sort of context where there's a relationship between the two that's, again, very complex, and where there has been a lot of back and forth and some blocking and unblocking and requests not to contact and then but we can if you apologize and all. So it's important to me that, in deciding whether communication is harassment, that notice to the person being restrained be, pretty unequivocal that, like, I don't want any more contact now. And it sounds like once that message was given to Miss Molina, it sounds like she has sort of respected that request, and her posting on her own social media about, what she might do next, that's not necessarily violating that request. She's able to post on her own social media account. And so, I think as far as that communication from Ms. Molina to Mr. McAdams in a way that would be unlawful harassment, I find there's not enough evidence for that based on testimony and what's in the petition. The other thing is I was asking about at the beginning that was concerning was threats that Ms. Molina made to Mr. McAdams or his family. And as far as the children living in New York, again, I don't find there's sufficient evidence at this point for that to constitute unlawful harassment. And it sounds like where there may have been some threatening comments about, I don't have to fight, I can just shoot. That may have been directed at Mr. McAdams' ex-wife, who's not a party to this. And while that may obviously impact Mr. McAdams, I'm not saying it doesn't, as far as the court issuing a no contact order because of that, I'm not finding evidence that there was those direct threats, to Mr. McAdams, or that they were directed at his ex-wife in order to kind of message him for that in an indirect way. So on balance, I don't find from the evidence at this point that there's sufficient evidence, which would be evidence by preponderance, so more likely than not. I'm in a public place. I'm allowed all six of those elements I went over. I asked the people around me. They said it's fine. I was here first. If you don't like it, you should go outside. So with that, I'll be signing the denial order. Mr. McAdams, do you have any questions, sir?
All right. Let's give this a try.
That beefy boy sandwich don't mean shit right now. That's not the start of the show anymore. No,
because of it, you wanting to decline it. I'm afraid of her threats of, like she had stated, of her having 4 other people who know where I originally planned on moving in, and her threats towards sending somebody to my work, like I had put in a screenshot from her friend threatening me, her taking and sending me a cash up offer, trying to have me pay her money, and told me if I didn't pay her, she was going to have somebody come to my work.
Are you asking for me to? Are you asking to sort of reconsider? Or are you saying you're concerned about future actions now?
Further actions due to effect of her threats towards me and my ongoing from here on.
Yeah. So at this point, it sounds like you earlier made a pretty unequivocal statement to her that you didn't want any further contact. And so if you gather evidence that there's additional contact, you're always welcome to refile. Deny it. I'm denying it based on what's in front of me right now. That doesn't, now restrain future petitions. If additional information comes in that you want the court to consider, you're free to file that. And the same goes to you, Ms. Molina. If you have evidence that you'd like to present to the court, what I'm finding today is based on what's before me, that at this point, there's not sufficient evidence for an anti-harassment protection order. So again, sounds like there's been unequivocal notice given from Mr. McAdams to Ms. Molina that he doesn't want any more contact from her. So, Mr. McAdams, if you feel that you've got evidence of the contact after this you'd like the court to consider, you are more than welcome to submit it. But for today's hearing, based on what's before the court, I'm denying the petition. Ms. Molina, do you have any questions?
This doesn't stop me from filing my own protection order, does it?
No, this is all just what's before me right now. Okay. For protection order from Mr. McAdams against you, I'm not finding sufficient evidence.
Okay. All right. Thank you.
Thank you, Ms. Molina. Thank you, Mr. McAdams. You're both free to log off.
Have a good day.
You as well.
It was all my fault. The strange sounds you heard. Crazy commentary. I was checking a message on my phone. This is gonna be bad. Oh yeah, I knew this. I had all this set up, then is it all this? There we go. All right. So I was checking a message on my phone, and I clicked the little thing and didn't realize my headphones were attached to my phone. And it did this whole little thing with my computer where it stopped hearing the computer, and when it came back, there was a video in some astray Chrome tab that was open where I was watching Penguin ZO review a video of a guy getting into a fight with some people while he was trying to review a beef sandwich. It was literally a fight over a review of a beef sandwich at a Mr. Beef in Chicago. You can't make this stuff up, ladies and gentlemen. That's what you heard in the background. I had forgotten to stop it before I started streaming. And yeah, sorry for the adult language there in the middle of a PPO hearing, which was a pretty good PPO hearing in my opinion. I wasn't trying to make fun of the way the guy talked, but oh man, it just brought back all the old Elmer Fudd memories and the Princess Bride memories, loved it. But yeah, Chicago's. And I do want to say a special thank you to all my friends out there that I always forget to thank you. Especially tonight, Specs and Kiernoff. I think there was, hold on, I want to refresh my little thingy over here. This is Natasha Kitty. Here's looking at you and all you crazy stream participants out there. All of you, thank you so much for hanging out and making the chat a lively place. While the World Cup is on, we're still watching court every single night. I'll be here, same wolf time, same wolf channel, with more court content tomorrow, the same general time. It looks like the web internet stuff, it worked fairly well tonight. We didn't have a lot of that the old drop frames, spinny things. I was happy. We might do it again live tomorrow. If I start seeing things that are acting weird again, I might have to just do a premiere. But we're going to have more court content, and we will have a live chat. And we'll all be right here watching more court cases as they happen. I found a lot today, ladies and gentlemen, and that was just one piece of the PPO hearing from today. There's a lot more that we'll probably watch on Saturday. I didn't want to throw it all in the same show. I wanted to have a little bit of variety in those Hesselink cases. Man! Oh my Lord! Judge Hesselink was on fire today, was he not? I couldn't get over it. Judge DiSanto had a few things to say too when she sent the old lady out the other door does from time to time. We don't see that often. We do see it close. Ladies and gentlemen, I am your lone wolf Oostel. I am out. I feel like it was a little rushed. Was it a little rushed? I don't know. You know, one thing's for sure. I may have more, but I'm not showing it tonight. So go. Go now and send no more. Bye. BLR. BLR. Play that funky music, Marty.